First of all, good afternoon, everybody, and thank you very much for joining us at this Bristol Law Society webinar, which is all about lawyers and litigants in person aimed at our civil litigation contingent. I'm here now to tell you that the PDF slides will be available later on, but please don't let that cause you to shut off your cameras and disappear waiting for those. And the webinar is being recorded. If you've got any questions as they come up, please use the Q&A boxes to fire those in. We'll be taking those at the end. That's always useful to hear from people as to specific things they may have questions on as things progress, so please don't be shy to do that. And do let us know of any other topics that you'd like covering if you are a litigation lawyer that's attending today. The Law Society is there to take information from its members and try and deliver the best value that we can do for you, so please don't be afraid to get in touch with us and let us know of any other topics that you might want covering. So without any further ado, I should introduce our speaker for today, which is Matthew Cannings, of Three Paper Buildings, Court of the Bar in 2006, and is currently the Head of Property and Estates at Three Paper Buildings. So who better to brief us on a professional lifetime's worth of crossing swords with litigants in person than him. So I shall hand over to you, Matthew.
Thank you, Stuart. Thank you, everyone, for coming along. As Stuart says, I'm Matthew Cannings. I'm one of the barristers at 3PB Barristers. I'm based on Victoria Street in Bristol. And Stuart and the Bristol Law Society asked me to talk to you about litigants in person. Well, Stuart said, would I do a talk? And I said I was very happy to do a talk. What would you like me to talk about? And apparently Stuart and the powers that be at BLS put their heads together and asked me to talk to you about litigants in person. I profess no specialist knowledge about dealing with litigants in person, but as you heard me just talking about with Stuart there, that they are part of the legal process. It's something that happens, something we have to deal with, and it's right that we as lawyers, you as solicitors, paralegals, barristers, I think we've got in attendance, that we deal with them properly and appropriately, and in a way that complies with our obligations to the court. What I'm going to do then is I'm going to start by talking briefly about our obligations and where they come from. Then you will be excited to hear there's going to be a small quiz. If we were all in person or you all had your cameras on, then I might put people on the spot and ask you to put your hands up at the very least and take a poll. Sadly, the wonders of modern technology do not allow me to do that. So it will all just be a matter for you to vote privately and have a think about whether you know the answers or not. I think they're relatively easy questions, but I'll give you some background to them afterwards. I'm going to mention the case of Barton and Wright Hassel, the Supreme Court judgment, which gave some comments on litigants in person and how a party being a litigant in person should be treated by the courts in terms of complying with rules, practice, directions, and court orders. And I'm also going to mention another case that I found, the Bristol District Registry case that some of you might have been involved in which Judge Matthews mentions the Barton and Wright Hassel decision. Then I'm going to give you my thoughts and my suggestions. They're nothing more than that, but it's what I think about a few things to do with how we should appropriately deal with litigants in person. And then I'll take some questions at the end. Stuart's going to deal with them, I think, and act as the chair. But if you have any questions, put them in the question and answer box as we're going along. And Stuart will ask me some of those at the end. Starting with me then, as Stuart said, I'm a barrister at Three Paper Buildings, and I've been in Bristol since about 2007, working from 3PB. I do all manner of civil work, but primarily property work and commercial work, particularly commercial work that has a property element, landlord and tenant work, both residential and commercial, and both for landlords and tenants, and real property work, neighbour disputes, boundaries, fences, easements, and those sort of cases in particular I find often have litigants in person involved. And obviously landlord and tenant work, if it's residential landlord and tenant work for landlords, again often you come up against litigants in person on the other side. So that's my background, that's how I come to this, and as I say, I profess no specific knowledge, but hopefully I've got some views I can give you that are helpful, and I'll talk you through some of the background to things. Very briefly then, starting off with obligations. The Legal Services Act 2007, Section 1, sets out that people who exercise a right of audience, by virtue of being authorised persons, should comply with their duty to the court to act with independence in the interests of justice. And what I did have for you was a couple of slides on the SRA Solicitor's Handbook. But then when I delved a bit further into my research, I discovered that they pulled the handbook a few years ago, and the SRA website now directs you to a catalogue of guides and rules and codes of conduct. So it wasn't quite so easy to shift through and find the succinct points. But the starting point is, as you know, although you have an obligation to act in the best interest of your client, you also have an obligation to the court to know your primary duty to the court. So there may be occasions when your primary duty to the court outweighs and must trump any obligation you have to act in the best interest of your client. So that's the jurisdiction for this. That's what we have to bear in mind. And it may be frustrating at times, and there may be problems with it at times, but clients need to know, and clients need to be aware that although our obligation as lawyers is to act in their best interest, there is one primary thing that trumps that, and that is our obligation to the court. I guess there are others in complying with our code of conduct and ethics obligations, but that's what I'm going to talk about today. And what we're going to start with then is a quiz. And as I say, sadly, I can't see how you're answering these, so you're on your own, but see what you make of it. I don't think it's too tricky. First one, does this apply to litigants in person? The Limitation Act 1980, what do you think? Well, the answer there hopefully is obvious. Yes, this is statute, this is law. The Limitation Act sets in place various deadlines or periods of time by which claims must be issued, and with very, very few exceptions, that is strict. And certainly the difference between being a represented party and a litigant in person has nothing to do with this. The law is the law when it comes to the Limitation Act. Let's move on to some more specific ones that are maybe a little bit different. The Civil Procedure Rules Part 3's requirements in respect of filing and serving cost budgets. What do we think about that? Does that apply to litigants in person? No, as I suspect you're all aware, it doesn't apply to litigants in person normally, but there are some exceptions or some ways in which it might apply, and I thought I'd point them out to you in case you weren't aware of any of this. So CPR Rule 3.13.1 says, unless the court otherwise orders, all parties except litigants in person must file and exchange budgets. So the starting point then is that represented parties need to, assuming it's a cost budgeting case, so most multi-track cases, represented parties need to file and exchange cost budgets. And the rules also set out that with a litigant in person, you still have to give them a copy of your cost budgets. Although it says exchange, it might not be exchange, it might be provide. But that's the starting point. And you can see there, the rule says, unless the court otherwise orders. So there's a discretion there as to what to do. Sorry, you're going to see quite a lot of words on the page now. Don't worry about noting them down. As Stuart said, you're going to get the PDF of my slides later on today or tomorrow, I think. So sorry for the words. I'll go through it, but you will see them again. In the case of Campbell and Campbell, Chief Master Marsh discussed budgets and litigants in person and said the default provisions for the service of budgets in Rule 3.13 exclude litigants in person because the majority of cases in which litigants in person appear will not require the litigant in person's cost to be managed. And that makes sense. But a litigant in person may opt to serve and file a budget, or the court may order a person to do so. So as I see that, if a litigant in person wants to put in a cost budget, then they're free to do so. It's not for the court or a represented party to stop them. But the other point there is that the court may order, so has a discretion to order a litigant in person to put in a budget. Master Marsh saying further, the court may decide to make a cost management order in relation to a litigant person's budget. So there's one thing of filing a budget. The next one is, do they actually go through does the court go through the budgeting process? Indeed, in a case in which a litigant in person is likely to be seeking a substantial costs order, whether because there will be fees of counsel under the direct access scheme or otherwise, it may well be desirable to do so. So this is something to bear in mind. Budgeting is what it is and it's here to stay. And we all know what we have to do as lawyers in terms of preparing a budget, filing it, what the deadlines are, and then what the process is at CCMC. But this could apply to litigants in person as well. The reality is, I guess we might not know at a budgeting stage what position the litigant in person is going to take. But if you happen to know a litigant in person is going to be using direct access counsel, that might be a reason to say, well, things should be budgeted. or if they've given any other indication that they are going to be seeking a substantial cost order despite the fact they're litigants in person. You may want to think about the fact that they can be ordered, the court has a discretion to order them to file a budget and then go through a budgeting process. So I put that there as a reminder, something that is worth knowing when you are faced with a litigant in person on the other side, in cases where they may still be seeking a substantial cost award. It is something the court can do of its own accord, but it's also something, as far as I see it, that a party could apply for and make an application that a litigant in person's costs be budgeted. Right, my next one then. Does it apply to litigants in person? CPR Rule 3.1, this is the court's general powers of management. Does that apply to litigants in person? Yes. Again, sort of course it does. That is the wide-ranging powers given to the court as to what they can do in cases and how they can manage cases and the various decisions judges can make. But the reason I put this in is because there is then a second rule that's been added in. This is Rule 3.1a. This is a specific rule about case management with unrepresented parties. And again, with apologies, lots of words on the screen, don't worry too much. This is coming out in the slides, and this is the entirety of Rule 3.1a over 2 slides. This rule applies to any proceedings where at least one party is unrepresented. Where the court is exercising any power of case management, it must have regard to the fact that at least one party is unrepresented. And what we'll see later is some of the speeches in Barton and Wright-Hassel mention that except when there are specific exceptions in the rules, everything applies to litigants in person as it does to represented parties. This is perhaps one of those exceptions. The court must have regard to the fact that at least one party is represented. And then it goes on at subparagraph 3 there to say, well, the starting point for multi-track and fast-track directions are the relevant standard directions, which can be found online. It then says they must be adapted as appropriate to the circumstances of the case. And of course, the circumstances of the case are going to include things like whether one or more parties is unrepresented. And the rule goes on to say the court must adopt such procedure at any hearing as it considers appropriate to further the overriding objective. So we're not just on case management and directions now. This is at any hearing. The court must adopt such procedure as it considers appropriate to further the overriding objective. We're back to interests of justice, like we saw in the Legal Services Act, and everyone knows about CPR Rule 1.1. And what the rule says further on there is, at any hearing where the court is taking evidence, this may include ascertaining from an unrepresented party the matters about which the witness may be able to give evidence or on which the witness ought to be cross-examined, and putting or causing to be put to the witness such questions as may appear to the court to be proper. So this is something for the court to bear in mind, but it's important that the lawyers know about this as well. So at any evidence hearing, so for us that's going to be trials, maybe certain applications, but primarily this is a rule about trials for us. The court is obliged to bear in mind that there's an unrepresented party and to ascertain, effectively to have a discussion if necessary with the unrepresented party about how the giving of evidence is going to go, what matters a witness is going to give evidence on. You would think that would be evident from a witness statement. And also the important point about cross-examination and putting one's case. And litigants in person might know they need to ask questions of a witness they're cross-examining, but the specific point about putting one's case, which is of course vital in cross-examination for a judge at the end, is something that litigants in person might not necessarily grasp. These are rules that we can point out to the court and ask the judge to deal with. Could also be raised at a PTR, I think, although it's not necessarily the case that you'll have a PTR in a litigant in person case, but bear those things in mind. Going back to the start of this rule then briefly, if the court is exercising any case management powers, it must have regard to the fact that one party is unrepresented. This is where maybe what a represented party might see as some sort of disparity might kick in. But the rules say this has to happen, and in my view, it's almost always fair and right that it does happen. If it's granting certain indulgences, sort of, such as extra time, perhaps, or extra explanations, or maybe being more understanding to a default. And again, we'll come on to that with Barton and Wright-Hassel. These are things that the court has to have regard to. And when it is case management, it's understandable why. It's very different to the end of the case when you're getting to the actual outcome of a claim. But when we're talking about case management, there are rules there that say the court must have regard to the lack of representation by one or more parties. Right, back to the next question on the quiz then. Does it apply to litigants in person? The guideline hourly rates for costs. And as you'll all know, the rates went up relatively recently after about a 10-year hiatus. Do those rules apply, or those rates apply to litigants in person? No. And again, I suspect you all knew that. But, and this is why I put this in, litigants in person can recover certain costs. And before we get on to the rule and the specifics, this is vital that you remind your clients or advise your clients. No doubt all of us know that when we're talking about cost-bearing cases, most civil cases, we will advise a client of their cost risk, and that's not only the cost that they're going to incur, but it's also the adverse cost risk in being unsuccessful, or because of the court's wide discretion in some way or for some reason, been ordered to pay some or all of the other side's costs. But what we might do is think, oh, well, there isn't much risk there when the other side doesn't have a lawyer. Again, one obvious starting point is that a litigant in person could always get a lawyer. They don't have to give any notice of that. You could suddenly get a notice of change through the post that says, well, we've instructed some very expensive lawyers. Thank you very much. And particularly at the end of a case, someone could get direct access counsel and you wouldn't really know until the day or a few days before a trial. But specifically, if it is a case where it's a litigant in person who runs it all the way through, they still can recover costs. And the starting point is actually not the £19 an hour that some of you will be familiar with. The starting point is that they can recover their actual financial losses up to 2/3 of the amount that a represented party would be able to incur. And if you have a look at Rule 46.5, you'll see it takes you through the sort of things that can be recovered. And essentially, they're the same sort of things that we would be putting on a cost schedule to recover on behalf of our clients, but subject to the 2/3 cap. If there aren't any actual financial losses, or to the extent we come outside of that, because disbursements are still recoverable, and it's easy to see litigants in person will often have court fees and might well have disbursements in terms of expert evidence. But outside of that, their own time, if they can't prove any actual financial losses, then Practice Direction 46 tells us that the rate is £19 an hour. But as to that actual financial losses, I had a little bit of a look into, well, what could that be? How do you show you've got your actual financial losses? And there is a case, it's unreported, but I got the date of it. It's the case of Spencer and Paul Jones Financial Services Limited. And this was a decision of of a master sitting in the senior court office. Senior court's cost office. And what happened in that case was the litigant in person was awarded his costs at a rate of £150 an hour. It's quite specific, this, but the litigant in person obviously did what they had to do to prove to the court that they had suffered a financial loss. And what happened in that case was the litigant in person worked for a legal services firm. I couldn't see any more details on that. But he said, well, it's my company, and I work all the hours I can, well, all the business hours I can for my business. And during the course of this litigation, I can show you that my business turnover has decreased significantly, or my work done has decreased significantly. And in that case, the litigant in person was able to show to the master that he normally earned this sort, or turned over this sort of money. And during the period of working on this case, that came down significantly. And what he said is, I work all that I can, no doubt defeating an argument that litigants and that self-employed people often face, which is you just need to find more time to do the work around your other work. But he got past that, and he said, well, I normally charge between £150 and £165 an hour. And because I've been working on this case, I haven't been able to charge my clients and to do work for my clients and charge that rate. So the master said yes, and the master awarded £150 an hour. So that is a warning there that litigants in person can, if they satisfy the right test or surpass the right test, can actually incur what we might call more like proper costs. Still, though, subject to the 2/3 cap that Rule 46.5 says. And another warning here, and something to bear in mind, is that the practice direction again says, well, if litigants in person wish to prove that they have suffered financial loss. So this isn't the £19 an hour type cost claim. This is the, as I said there in the Spencer and Paul Jones case, this is the I have incurred actual financial losses. Much like represented parties have to put in a cost schedule, litigants in person should produce written evidence in support, serving a copy of such evidence at least 24 hours before the relevant hearing. Worth bearing in mind if at the end of a trial, a litigant in person or a hearing, cost-bearing hearing, litigant in person stands up and says, I want my costs, and I'm not talking about £19 an hour, I'm talking about these other losses. Well, that has to be supported by evidence. The 24-hour rule is there as well, but we know the court has a discretion in that regard. I wouldn't get too fixated on that. But the fact it needs to be supported in evidence is important. I take that to be a litigant in person can talk about their £19 an hour without evidence. But if it's any other, if there's an allegation of suffering actual financial losses, they need to evidence those losses as well. Bear all that in mind. Right. The last one then, a bit silly, but no cheating. If you know this, I'm impressed. Rule 44.8, it's in the costs rules. This is a rule relating to what happens after certain cost orders are made. Does this apply to litigants in person or not? You either know this or you don't, and if you don't know this, if you do know this, as I say, I'm very impressed. This doesn't apply to litigants in person. This is a specific rule, which is common sense, and I'm sure you all do anyway, but it's actually a rule. Rule 44.8 requires a represented party, and I think I've quoted that slightly wrong there. It says represented party to notify that party. What it is that a representative of a represented party must notify that party, so must notify their client that a cost order is made against them within 7 days of the order being made. This is for situations where your client is not at court. You have to tell your client that a cost order has been made against them. You have to do it within 7 days because Rule 44.8 says so. And the practice direction at paragraph 10.2 also says you have to give them the reasons why. This all makes common sense, and I'm sure you all do it anyway, but it's actually in the rules, and that's an obligation on us as the legal representatives to tell our client what's happened. Of course, that doesn't apply to litigants in person. All right, I'm going to mention Barton and Wright Hassel now then, and I'm sure you know this. I'm not going to spend much time on it, but I'm going to put a couple of quotes on the screen. This is a case that ended up in the Supreme Court. It was a litigant in person who wanted to bring a claim and wanted to do so, or elected for whatever reason, to leave this until right at the end of the 6-year limitation period. He then elected to serve the claim form himself, so he held on to it. And he held on to it for something like 3 months and 29 days, and then decided to serve via email. And what happened was the defendant said, no, we don't accept service via email. And by that point, the 4 months had expired, time had elapsed. And because this litigant in person was right on the limit on litigation limitation for the 6 years, and then right on the limit for the 4-month period for service, he couldn't just start again. So he was asking for the court's indulgences for a retrospective extension of time, or I think for an order that his service was good service sent via email, even though service via email wasn't accepted by the defendant. It got all the way to the Supreme Court, and what Lord Sumption says, amongst other things, is that a litigants in person's lack of representation will often justify making allowances in making case management decisions and in conducting hearings. So that's what we were talking about earlier. Case management decisions, directions as you go along, maybe different time frames or extensions of time, for example, for litigants, and in conducting hearings. And we've looked at that rule that mentions specifically cross-examination or witnesses giving evidence, but it may also apply to the nature of a hearing, how a hearing takes place, whether it's a trial type situation or whether it's a submission situation. But anyway, lack of representation will often justify making allowances in case management decisions and in conducting hearings, but it will not usually justify applying to litigants in person a lower standard of compliance with rules or orders of the court. The overriding objective, mentioned again, and we've heard interest of justice, we've seen it in the Legal Services Act. The overriding objective requires the courts, so far as practicable, to enforce compliance with the rules, and a reference to Rule 1. The rules do not in any relevant respect distinguish between represented and unrepresented parties. And he went on to say, unless the rules and practice directions are particularly inaccessible or obscure, it is reasonable to expect a litigant in person to familiarize himself with the rules which apply to any step which he is about to take. Excuse me. So what we have there is a rule, or the question is the rule or practice direction that's been breached, that's what they're looking at here, particularly inaccessible or obscure? And if it's not, it's reasonable to expect a litigant person to familiarise themselves with the rules. And maybe there's something for us in lawyers here, in that we're not to, and we certainly shouldn't be providing advice to litigants in person, but we can explain things, or we can point them in the right direction. And certainly pointing someone to the CPR, where again we have Barton and Wright Hassel telling us that a litigant in person is expected to familiarise themselves with the CPR, that strikes me as good practice, and useful and a helpful thing to do. But what happened in this case, as I suspect everyone knows, is that the Supreme Court said, well, no, the rules about service, whether that's the timeframes and the timeframes for deemed service and the methods of service, they are not particularly inaccessible or obscure. And the court also said in that case that a litigant who waits till right at the end of the limitation period and then right till the end of the 4-month service period is less likely, I think the way it's put, to receive the court's indulgences when something goes wrong, which if they hadn't been so close to the deadline, there wouldn't be a problem. I did a search around then to look for other cases where Barton and Wright Hassel was mentioned, and I found a Bristol case. As I say, some people here may have been involved with it or may know about it. It was a local solicitor's local counsel. This was a decision of His Honour Judge Paul Matthews, sitting as a High Court judge. And there is a judgment on the substantive trial of the action, but then there's also a judgment available as to the costs or the consequences following the handing down of judgment. And it was to deal with costs, what cost order should be made in principle, should there be an indemnity cost order made, also whether there should be some reassessment and also a permission to appeal application. But the judgment is useful in terms of the comments that the judge makes about litigants in person, and it's an example of an application of Barton Wright Hassel. It's also an example of a litigant in person who maybe doesn't deal with things as best they could or should. The background to the case was a Section 117 Companies Act application. It was a defendant, the litigant in person, was seeking to have an order under the Companies Act that certain documents be disclosed. And the foundation, the claimant, actually sought, I think what must have been a declaration that they didn't have to comply with the notice they've been served to provide certain information. So that's what happened. The application or the claimant was successful in proving they didn't have to provide any documentation. And then there was an issue to costs, and the judgment makes interesting reading. It gives some examples of the litigant in person's conduct and what the solicitors on the other side and the claimant company had been faced with. And as an example, a point is made about correspondence that was wasted before the PTR about whether the trial should be live streamed. It was going to be a remote trial, and seemingly quite a lot of correspondence passed between the claimant and the defendant in person, claimant solicitors and defendant in person, where the defendant was saying this must be live streamed. What the judge goes on to say is actually at the PTR, the point was conceded quite briefly, but apparently what the defendant was saying is that there were going to be hundreds of people who wanted to watch this live stream. When he got to PTR, he didn't push the point, conceded it quite quickly, conceded it without argument, is what Judge Matthews says. And in the end, 14 people did obtain the link via the court in the normal way, like any other remote hearing is accessible. And that's an example of correspondence that was wasting money, didn't come anywhere, wasn't a point that was particularly taken when the matter got to court. And the judge goes on to say the defendant's correspondence once again shows him as difficult to deal with, condescending and indeed offensive. Then there's an example of the correspondence that passed between the claimant and the litigant in person defendant in December 2020. The judge gives an example where the defendant sent 46 emails or letters to the claimant, whereas the claimant sent 9 emails or letters to the defendant. And the judge describes the disproportionate efforts on the part of the defendant there. The defendant also made various allegations against one of the claimant's witnesses, I think a director or a member of the claimant company, but she was alleged of deceiving the court and perverting the course of justice. And the judge says, in my judgment, I expressly stated that I found the witness to be telling the truth in evidence she gave to court. There was also an accusation by the defendant in correspondence that this witness is guilty of fraud proven to the criminal standard, was the quote. Seemingly, Mr. Litigant in person had become jury and executioner, or judge and jury, and the judge Judge Matthews says, but no such thing was in fact proved. And then the judge goes on, and what he finds is that this is a case where a cost order should be made, and in fact an indemnity cost order should be made. And again, with apologies for all the words on the screen, the judge says, my overall assessment is that the conduct of the defendant in the present case was well out of the norm in the way he approached the inter-parties correspondence and in the language and tone that he employed in conducting it, in the way that he attempted to put in large amounts of irrelevant material as evidence, and in the way he made unsupported accusations of serious offences against the claimant and its directors. The defendant is, as he more than once reminded me, a litigant in person and not a qualified lawyer, but that does not excuse him. There are not two sets of rules for litigation in this jurisdiction, one for represented litigants and one for unrepresented. As Lord Briggs said in Barton and Wright Hassel, save to the very limited extent to which the CPR now provides otherwise, that's what I talked about earlier, examples such as that rule 3.1a, there cannot fairly be one attitude to compliance with rules for represented parties and another for litigants in person, still less a general dispensation for the latter from the need to observe them. In any event, the evidence has disclosed that the defendant is intelligent and articulate and an experienced litigant in person with access to legal resources. The problem is that, being neither professionally trained nor qualified as a lawyer, he has no sense of responsibility to the system, no duty of the kind that would be owed by a lawyer to the court and sanctioned if breached, and no professional reputation, to lose. In my judgment, this is a clear case for cost to be assessed on the indemnity basis, and I will so order. So there's an example of how Barton and Wright Hassel was applied by one of the Bristol judges. Right, moving on then to the final part of this, and I thought I'd give you my thoughts on litigants in person and the interaction between lawyers on one side and litigants in person on another. And the two important points, I think, is that at an interim stage or a case management stage, and again, we looked at rule 3.1a, which mentions that a court must bear in mind at case management stage and when dealing with certain hearings that a party is unrepresented. At that stage, the reality is litigant in person might be indulged by the court, particularly when it comes to discretionary decisions. And this is something that we have to accept. It is how it works, and it is, in my mind, just. Litigants in person, for example, might need more time to do things, or they might not anticipate how much time it takes to do something. We all know, both with represented parties or unrepresented parties, you can get someone who gets very close to the deadline and realizes they're not going to do it. Or they might just forget, and anyone can forget whether they're a lawyer or not. If someone's making an application for an extension of time or relief after the event, it strikes me as being fair and being right that if the case justifies it, there will be certain indulgences granted. And it's worth us accepting that, in my view, and explaining that to our clients, who will no doubt be frustrated by that sort of thing. But it's not unjust. But when it comes to the overall outcome of a case, where a party has legal representation or where a party doesn't have legal representation, should not have anything to do with the outcome of the case. They shouldn't be, and in my experience aren't, treated with more indulgences because they're a litigant in person. And that has to be right. But it also goes the other way, in that a party that has a lawyer shouldn't be winning because they have a lawyer. Justice isn't served in either way. And that again, I think, is something I think that's useful to explain to our clients. There's a difference between what might happen at an interim stage or at a case management stage compared to what happens at the end. When you get to the end, the law is the law, and it doesn't matter and shouldn't matter. And it's entirely right that it doesn't at that stage matter whether a party is represented or not. And some suggestions from me, my final thoughts on this. So a few on the screen. Like I've just said, explain to your clients what might happen, or what is happening if you're in the middle of a hearing and you can do it, or what has just happened. And clients will get frustrated. But as I say, at this interim stage, it is understandable, and it, in my mind, is just. And where we come back to is the overriding objective in the interest of justice. It is right that on occasion, if the facts justify it, that certain indulgences will be granted. But that is, as I say, a case management type situation, how hearings are conducted. That's not the actual outcome of the case. That's a different point. If in doubt, do more, not less. And when I looked at this morning, I thought, oh, well, with a word of caution on this. But what I mean is things like, you might know that a claimant is required to prepare a bundle, but the claimant's unrepresented, help them out. Your main obligation still being to the court, bearing in mind your duty to ask the best interest of your client. But things like preparing a bundle, even though it's not your objective to do that. You will face with hearings where they might be a mess if there's not a bundle. If you can help the court out, help yourself out and your client out by preparing a bundle, do that sort of thing. Also, that comes into explaining things to a litigant in person. Don't advise. It's not our job to advise litigants in person, but explaining things to them. For example, pointing them to the CPR, pointing them to the right web page, or pointing them to an order that's been made in the past. Explaining things is an acceptable thing to do. And leads into the next one, which is be helpful. The court will be grateful if you do things that are in line with the overriding objective in furthering cases and getting them to a point where they can be litigated, whether it's a trial, things like I say, like a bundle. I had a hearing a few weeks ago where the litigant in person on the other side was supposed to have brought a hard copy of the bundle to give to the court. They didn't, I did, and I was able to hand up a copy to the judge. Doesn't affect the outcome of the case, but it certainly saved us an hour of the litigant in person being told they had to go and find a printing shop somewhere and print off another copy of the bundle. It helped everyone just to get on with things. Fourth, be patient. And fifth, I guess, comes in together. Don't be drawn in by a litigant in person who might be like the litigant in person in that Sir Henry Royce Memorial Foundation case that I quoted. We know that we are the professionals and we must not get drawn into to the difficulties that might be being caused by a litigant in person. Of course, it's not every litigant in person, but that case was a particular example of a litigant in person not acting as they should. Don't be drawn into that sort of behavior. Remember your obligations and remember your duties. And a couple of other things I thought about. One, basic one, it's day one of law school, I think, but make good attendance notes. If you're having telephone conversations with litigants in person, you may think it's a basic conversation. You'd always make an attendance note, no doubt. But if you had a 5-minute conversation with your opposing lawyer about what time does the hearing start tomorrow, you'd make a very minimal note at all. But you may think something was a very basic conversation. The litigant in person may take a different view of what was said or what wasn't said, for example. So cover yourselves and protect your position with attendance notes that might be helpful further down the line. And the final one, obviously, those first letters that are sent, if you're on the claimant's side, will say to someone you think is going to be litigant in person, we advise you to take legal advice, or we advise you to seek legal representation. For a whole manner of reasons, people might elect not to do that or might not be able to do that, particularly if it's a financial constraint. Maybe, and again, it needs to be fact specific, but particularly if you've got a case where you think you're on clear ground, and if that litigant in person saw a lawyer, they might understand it too, and it might help you reach a settlement or make something end much quicker and much more proportionally than it might otherwise do. Maybe say, well, if you're not going to get a lawyer to represent you, why don't you seek a one-off bit of advice? Go and see a solicitor or maybe direct access counsel just for a one-off advice on the merits of the case. And maybe that draws them into finding out a bit more about the legal background and the legal basis of why they might succeed or might not succeed. Those are my thoughts. I'm very happy to take some questions. I can see something's been popping up on the chat. And Stuart, I think you're going to jump in now with some of those questions.
Indeed, yes. Thank you, Matthew. I think there's a couple that starting to filter into the chat box, and while they're doing that, I've got a couple of notes that I've made about topics that I've been asked about in the past on this, which I think just might have been answered quite a few of those by your summary at the end there. But I think one of the things that we have to grapple with as practitioners on the solicitor side of it tends to be the unpalatable position of assisting the opponent more than you would do normally, but actually having to bill your client for that extra work in the hope that you may well recover that if you're successful at the end of matters or if a deal is done. And I suppose really it's, as you described, about where do we draw that line and the kind of things that tend to be deviations. I wondered if perhaps with your experience of what the court tends to direct in those circumstances where there is a litigant in person, what are the most common things within sort of standard directions that you would find where a greater onus is put on the represented party. For example, I'm thinking of things like instructing experts. We might be told that we have to take the lead in drafting the letter, etc. Is there sort of a pattern of things that you routinely think when you're going into a situation like that, this is what we're likely to be asked to do?
Well, I think you've probably got the main two there. So bundle preparation is an obvious one, and it's just going to help everyone. Even if there isn't an order, say the normal rule will be the claimant is preparing the bundle, but the claimant is unrepresented and defendant is. If it's picked up earlier on, often if it's a fast track case, of course, you won't have a directions hearing and the orders they'll be made on the papers. It might not be picked up. You may be faced with a choice there whether to help or not. And this is where I say, well, probably be more helpful than not. But you could at least prepare an index to send to the litigant person on the other side to say this is what we propose, as opposed to waiting for one to come in. But yes, standard sort of things are the represented party prepares the bundle. If it's a joint expert report, again, it probably makes sense for the represented party to prepare at least the first draft of an instruction. Skeleton arguments, you'll often see, well, the represented party must prepare a skeleton argument and the unrepresented party may prepare a skeleton argument. Or maybe things might be sequential in terms of skeleton arguments, which you wouldn't normally see, and the represented party goes first and the unrepresented party can go second if they want to. One thing I would say about it's a hazard, and it is an inevitable consequence of some of this, that a represented party might end up incurring more costs when the other side is unrepresented, partly from having to do more work, or partly just because there is more communication that might pass with an unrepresented party. It's unavoidable. The silver lining, if there is one, I guess, is that although there's an increase in costs, there is less of a cost risk, although the circumstance can change. But if you're doing that work and you've got a litigant person on the other side, assuming it's a cost-bearing case, if the case is lost and the litigant person gets a cost award, they're not going to be getting the same sort of cost awards that they would be getting if they're represented. So that's probably the silver lining to that position.
Yes, and I think one of the anomalies to that actually might be just sort of mentioning and flagging to people is where the litigant in person is in fact themselves a lawyer of some description. I know that's come up a couple of times as one of those anomalies where there is a suggestion that they can recover their sort of standard hourly rates on the theory that they would have been paying somebody else to do it. I don't know whether the 2/3 cap applies or not.
Yeah, so I think it does. So what the rule says is litigants in person includes, and there's a list when one is representing themselves, and it includes solicitors and barristers. But then, and there is an exception to partners who are then being represented by their own firm, because there's a different rule if it is a partner who is a litigant in person but has their own firm involved. That rule seems to apply only to partners and not to other fee earners at the same firm. So there are a few exceptions, but the self-employed point is perhaps the point that comes out of the Spencer case that I mentioned, that the litigant in person in that case satisfied the master that he normally worked every hour that he could for his business. And that defeated, I think, the argument the self-employed people face, which is, well, you just fit in more time to do this. You'll still have taken on all of your barrister work or all of your solicitor work, and you'll have run your own case. And therefore, you haven't suffered any financial loss. But I still think that 2/3 cap, I haven't looked into it specifically, but I would anticipate that 2/3 cap still applies regardless of what someone's background is.
Yeah, certainly a point worth bearing in mind to argue, because it's reducing it by 1/3 is certainly something you're likely to be grateful for in the circumstances. One thing to round off, and before I go to the other questions that came up as a pre-thought, is a lot of the time the difficulty caused with dealing with litigants in person can be an inherent suspicion that anything we say is for the benefit of our client, and they don't necessarily think that we are trying to just do the best thing for the proceedings as a whole. I suppose perhaps the thought would be whether it's good practice to, at an early stage in the case, write to the litigant in person, explaining your obligations and how the duty to the court overrides all else, and that as a consequence, if they do need signposting, it's with that intention.
Yeah, so I guess it's whether you say that right at the outset, and a litigant person might think, well, why are you saying this to me? And is someone protesting too much? Or whether you get a feel for an opponent and think, well, I probably should go there. There was some guidance, I'm not sure if it's still there, some SRA guidance, which was about lawyers and litigants in person. And the suggestion was that's something that lawyers could send to litigants in person for them to see. And it set out that a solicitor acting for your opponent has these obligations, and there are these obligations to their own client, but there are also these obligations to the court. And that set out, I think, things like they cannot mislead you, they cannot bully you, they cannot say things to you that are not true or not sustainable. So there is something there that it's still about that could be sent to litigants. But yeah, what I think you say is a good idea. My view, it's slightly different from a barrister point of view, but I will meet litigants in person at court. And if necessary, I will say, well, I represent so-and-so, and my primary obligation is to him, but I can tell you I also have my ethical rules, and I can't mislead you, and I can answer questions, or you can ask me questions, and I'll answer them if I can. And I try and be helpful, and some people are more receptive to it than others, but at least I know then I've tried to assist.
Yeah, I think you're right. It's about trying to remove those roadblocks, because I suppose a lot of people attending and tuning into this are doing so because they've had experience with litigants in person. And I think most of us would agree that most of them tend to be more painful than not. And so ways to be able to try and deal with that early, although they are more people management points than they are legal practice points, perhaps, definitely worth bearing in mind and hearing from some more experienced practitioners. So I'll move on to some of the questions that we've had come through in the box, and if anybody who's still tuned in is thinking of any others, please do fire them in. We'll be pleased to deal with them. The first one says here, I was served a notice for a hearing at the county court, but then on the day of the hearing, the claim was transferred to the High Court. As I was only given notice of hearing for the county court, should I be served a notice of hearing that the case would be heard at the High Court, and how much notice should a court give for a change of jurisdiction? That's a little bit off-piste from what we're dealing with today, but I wonder if there's a quick answer you've got off the top of your head there, or whether that's a deeper question that's more fact-specific.
Yeah, I mean, I guess the question is, it's still in the same building. This isn't I've turned up to one building and I've been told, oh, it's been transferred to the RCJ in London, but I was in Snaresbrook County Court or something like that. If it's in Bristol, I guess it's you've turned up thinking you're in the county court and you find out actually it's a High Court hearing. It could be that simply the notice of hearing was sent out on the wrong heading, or the wrong stamp was put on things. I'm not sure there's an obligation. I'm not sure anything is really triggered by whether you're in the county court or the High Court. Thinking through the litigants in person position, though, I guess maybe someone might have instructed somebody like a solicitor's agent who might have rights to appear in the county court in certain cases, but couldn't appear in the High Court. And then I guess maybe someone could be seeking an adjournment saying, I didn't know this was a High Court case. But I would think just on generally, if you turn up thinking it's a county court case and you're told it's a High Court case, I'm not sure there's any prejudice that you've incurred there by actually being in the High Court instead of the county court. So I'm not sure there's much you could do about that.
Thank you. And the other one that's dropped in is how do fixed costs impact on the litigant in person's cost entitlement? I.e., if they're seeking the £19 per hour.
So if you're in a fixed cost regime, then it's still your fixed costs rules, isn't it? So I guess someone might be thinking about, well, if it's a small claim, then you can have the solicitor's fixed costs on issue. They wouldn't apply. I can't see that they'd apply to a litigant in person trying to somehow seek the £19 an hour. If you were talking about a fast track case, well, generally costs are at large, but there's the specific advocate's fees. Maybe you can run an argument to say you're entitled to 2/3 of what the advocate would be entitled to, assuming you'd showed your loss. I'm not sure the £19 an hour would bite there, because that rule about advocates' fees is very specific, and I know there's some authority on whether a court can deviate from the advocate's fees. I would think generally the court is going to follow what the fixed costs say, because those rules are very strict. And if you're a litigant in person, you're trying to get things into 46.5, or there is a mention for fast track cases It's 45.39 subparagraph 5 subparagraph B. So that's about fast track costs. So maybe that's worth having a look at. But I think the starting point and probably the end point is the fixed cost.
Thank you. And I don't think we've had many others in, so I'll finish with a bit of a loaded question here, and watch your dance around it. But I think one of the true things that we're all thinking about when we're dealing with some of the nightmare litigants in person is, at what point do they cross the threshold from standard costs into that of unreasonable conduct? Because if it was a represented party behaving in that certain way, you would absolutely be thinking about making that application, but there's always that doubt in your mind that the leeway that will be given will be greater for a litigant in person. And so what kind of tolerances would you suggest would be trigger points to look for before actually thinking about making that application?
Well, I think probably the case I mentioned earlier, Sir Henry Royce Memorial Foundation against Hardy, is probably a good starting point if a lawyer wants to have a look. And it's a high court case. Of course, it's not an appeal case. It would be persuasive, perhaps. It depends where you're at as to whether it's binding or not. But the examples in that case were pretty bad, and they were cumulative, I think. That's my reading of it. And they led to an indemnity costs award. If you were talking sort of small claims costs or trying to get out of a fixed cost regime, then you're saying it's analogous with an unreasonable costs argument. But we had in that case, one example is of the voluminous correspondence that was caused by this thing about whether there should be a live streaming of the trial, and nothing came of it. So it appears to me that Judge Matthews said, well, that was a waste. That the same paragraph ends by the defendant's correspondence once again shows him as difficult to deal with, condescending, and indeed offensive. So those are maybe things you're looking for. The example, it was one example he gave was in this 1 month when there were 46 emails and letters going one way and only 9 going the other way. So again, if you can pin down and say, look at all the correspondence we've had to deal with. The allegations, the particularly unfounded and unpleasant allegations made against one of the claimant's witnesses, that she had deceived the court, had perverted the course of justice. And the quote is that the defendant said, she is guilty of fraud proven to the criminal standard. And seemingly, he didn't mean that there'd been a criminal trial and that she had been found guilty by her peers. It was simply he had determined that she was guilty of fraud proven to a criminal standard. And the judge says, well, no such thing was proved before me. So those are examples of when you're getting to the right sort of phrase, right sort of thing that might allow you to run that argument. But even then, that's cumulative, I think. And to a degree, we have to accept that there is going to be some behaviour that we know just wouldn't be what a lawyer on the other side would do, but it's a litigant in person, and it is the nature of, or the occupational hazard that I talked about at the start.
Well, that's it. And it also comes back to your advice earlier of trying not to get drawn into it. You know, there are some points where you do need to set out what the opposing points are. But after you've said that for the 5th time over, you know, perhaps your email should read nothing more than please see previous correspondence. There's one last one that's popped in then just to finish this up, because I appreciate we are running over time. The question saying, in a fast track case, is a litigant in person, presumably who is seeking costs, are they obliged to serve an N260?
No, they're not. Good question. So this is that rule I talked about, the reference to practice direction that says if they are saying that they have suffered specific financial losses, they need to put in evidence of those losses. But a cost statement, of course, there's no indemnity statement they need to sign in relation to their own costs or losses. They're not signing to say they have are liable or will be liable to pay these things. If it's the £19 an hour, I've seen people who have put down some sort of schedule and signed it, and they've carried out some calculations. That's obviously going to help the judge. But I've also had people who stand up at the end and just say, well, I've done this and I want my £19 an hour. But it's that specific, if it's an allegation of actual financial losses, like in the Spencer case, then the practice direction says they need to put in written evidence. So it's not a cost schedule, but we take written evidence to be a witness statement verified by a statement of truth, I think. and failing which, I guess it's invoices or that sort of thing. But in that case, he was explaining how much work he'd done, that it was at the expense of the work he'd done for his business, and that he utilizes all of his time normally to work for his business. That must have been in a witness statement, I think. And the practice direction says that should be in 24 hours in advance. So it's very similar to a cost schedule.
Great. Well, thank you very much. I think that's all the questions we've had through. Thanks to everyone for joining us today. You can see Matthew's contact details are still up on the screen, so do scribble them down if there's anything that you need to go to him for in terms of questions or indeed cases against litigants in person. Something that Matthew, I'm sure, will be very pleased to assist you with, and very grateful to me for pointing him in the direction of giving him the extra trouble with them. But thank you all for joining us.